Good evening, Chair. I'll go ahead and start a roll call, like you said. Chair Bizzle. Board Member Berry.
Present.
Board Member Perricone.
Present.
Board Member Wiggins. Board Member Warta.
Here.
Board Member Maida is excused. And Board Member Spicer. Thank you.
Thank you. Moving to our second item tonight, swearing in of new members, and one of our members here, Karen Spicer, and welcome to the Board of Adjustment.
Thank you.
And I guess we'll just ask you to go down and be sworn in. He helped write the UDO, and so several of us got to know him back then. But Chad, glad to have you tonight, and the podium's yours.
Chair Bizzle, if I may interject, right before Chad gives his presentation, the Deputy Town Clerk did give some of the board meeting minutes for the November 20th meeting date. If you all have those and have had a chance to review those,
Okay.
and we can take an action to approve them this evening if you so wish, sir.
I'll make a motion to approve as written.
Second.
We have a motion and a second. Any discussion? All those in favor say aye.
Aye.
Opposed? Motion carries. Thank you. Okay. And I think they're already signed too, right? Okay, we're ahead of schedule. Great. All right, Chad, it's all yours.
Hey, am I on? Okay. Good evening. Good evening, Mr. Chair, Board of Adjustment members. I am Chad Meadows, and it's a pleasure to see many of you again and meet some new folks here. Staff asked me to come and talk with you guys a little bit about Board of Adjustment stuff, and I know at least 3 of you are very seasoned. Karen, welcome to the club. I love talking to people and doing Board of Adjustment trainings because I serve as the Board of Adjustment Chair for Durham City County and have done so I'm in my 3rd year. We're a consolidated local government there. I know you guys know the term limits for boards of adjustment and so forth. I'm blessed in that we have a city and a county, both of which you can make appointments. So I will spend 12 years on the Board of Adjustment. I'm halfway through my sentence. I say that, facetiously. I enjoy it very, very much. And I want to share with you guys tonight some of the things that I've learned in my tenure on the Board of Adjustment in Durham. And then I'll also talk a little bit about some of the constitutional aspects, some of the provisions in 160D. We'll talk about, staff had asked me to spend some time talking about quasi-judicial evidentiary hearing processes, kind of start to finish. And so let me just get started here. I also want to talk about some of the Board of Adjustment best practices. As I understand them, I'm envisioning all of this session as much of a discussion as it is a training session. I know that you guys, or most of you, have a significant amount of experience working with the Board of Adjustment. My guess is that you have questions about how things are done. You've probably got some suggestions about maybe things that could be done in new and different ways, and I'd like to talk about that if that's something that you guys want to explore. I'm happy to explore some of that with you. At the bottom of the hit parade here is a section I'm calling hypotheticals, and my sense is what we wanted to do, and I'll just put this out here so you guys can know about it and think about it as we move along. For me and for the training, that I go through as a Board of Adjustment person, in the community where I live, some of the most helpful trainings are actually the ones where we sit down and we go through kind of mock hypothetical cases, where we're taking up particular issues, and we're talking about them as a group, in some kind of facilitated training discussion. Now, that kind of training is it's a lot of fun to do. It takes a little bit of effort. And I've put together some ideas for us to talk about tonight. I don't know that we'll have enough time to get through items 1 through 4 and into the hypotheticals without completely burning you guys out. I was told, hey, keep it short, Chad. You guys know me. I could talk a lot, but I thought that we might take an hour 15, hour 20, break in the middle. And then if you guys are interested and we still have some time, we can talk about maybe some hypothetical situations that you guys would like us to go back and kind of put together some mock cases that we can work through, when y'all's agenda makes some sense. I'll come back and we'll spend some time going through some cases like that, if that's something that you guys would like to do. So, I have some suggestions on those slides. I don't have hypothetical cases prepared tonight, though. If we have time and you guys want to do something, that's fabulous. We can do that as well. So unless there are any questions, as you guys know with me, I'm not you don't have to raise your hand and go through all of that stuff. If you have a question or whatever, please shout out. We have these same kinds of microphone boxes in our world, and you push the button and then you got the green thing. Hopefully you guys got the equipment that allows more than 2 people to speak. In our system, our microphone system allows only 3 people to speak at once. So you have to turn the microphone off when you're done speaking. Otherwise, other people who want to talk can't. So the reason I say that is I know when that green light comes on at the top that somebody's got their microphone on. So that'll obviously be a signal that you want to say something. But I just want you to be sure you don't have to. We're not standing on formality or anything like that. This is absolutely a training session. So any questions? Okay. All right. Very good. All right. So we're going to start up high and work our way down. I know that you guys are very familiar with this kind of stuff, but I always start these kinds of discussions with why do we have a Board of Adjustment, right? And the reason why we have a Board of Adjustment is that under the federal Constitution, specifically under the 14th Amendment of the Constitution, everybody in the United States has 2 fundamental rights that are relevant to the development review process that the Board of Adjustment is responsible for protecting. And the first of those is due process, and the second one is equal protection. Okay? And so the 14th Amendment, or at least parts of it, read, "Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law." In other words, everybody has a shot at justice. And the Board of Adjustment is one of the ways that shot at justice is embodied. If you need a variance, if you have an appeal, if you need a reasonable accommodation, then those are the mechanisms that are built into the regulatory process to protect people's access to fairness and due process under the law, okay? So that's very, very important, and y'all are one of the only bodies, you're one of the only checks in the system to protect people's due process. Also, equal protection. In other words, we treat everybody the same under the law. Conrad doesn't get a permit approval because he's Conrad or because we're friends or because, you know, I know his sister or whatever. Everybody is treated the same. And that's one of the laws that's enshrined in the Constitution. And you guys are also on the hook for making sure that that is protected. And it is the recognition of due process and equal protection that gives rise to a lot of other important concepts like fairness, impartiality, and other things that we'll talk about as we kind of move along, all right? Questions about due process, equal protection, the 14th Amendment, how all this stuff works? We kind of start up high, you know, we're at 30,000 feet, but this is the basis for why we've got a Board of Adjustment in the first place. Those two clauses in the 14th Amendment of the Constitution are why the Board of Adjustment exists, okay? Okay. Now, all municipal incorporations are children of the state, right? The state is the supreme sovereign that governs your charters and your ability to regulate land use and control what people can do with their property. And the general statutes has many, many, many laws, and I know that you guys know that. There are 4 main sections of the general statutes. This slide has the webpage address of the general statutes. Have you guys ever been to the website to look at the statutes? Have you done that? Yeah? Probably. If you haven't, do it. Go check it out. 160D is the most important chapter. That's the one that relates to land use. However, there are many, many, many other chapters. 160A is very, very important. 143 is very important. There's a handful of chapters that have relevance to the decisions that you guys make, and I encourage you to become familiar with the statutes. 160D 302 is the one that establishes the ability of local governments to have a Board of Adjustment. Okay, so 302 is the one that allows Clayton to designate or delegate their review authority for certain kinds of applications to this body. You guys are obviously appointed, you're not elected. However, you have the ability, particularly in the case of appeals, to act as a judge, to act as a jury, to allow particular kinds of uses and configurations in ways that only an elected official would be allowed to do. And so you've been delegated that authority, and the authorization for that flows from 160D 302. So it's an important piece of information. In addition to establishing the Board of Adjustment, the statute also sets down the various ways and means that the Board of Adjustment can use to make decisions. 405 is the appeals statute. 406 is quasi-judicial procedure in general, right? And 705 is quasi-judicial zoning decisions, all right? And so we're going to talk about quasi-judicial tonight, quasi-judicial procedure, evidentiary hearing procedure, which I understand can be frightfully boring. On the other hand, it's very, very important to understand. And I'm hopeful that you guys will have some questions about how that works. But I want to be sure that you know that everything that I'm going to say to you and that everything that you're already doing is backed by state law. There's the federal law that says we must protect equal rights and have due process. And then there's the body of state laws that we use to say this is how we're going to do that with the Board of Adjustment. Okay? Questions? Okay. Let's talk about the UDO, the Unified Development Ordinance. Okay, so your Unified Development Ordinance is still fairly new. And 3 of you were very, very involved in it. And, you know, I hope, first off, thank you for y'all's involvement in it. I know that it's a much, much better document because y'all were involved. It's been around. It was adopted on January 2nd of last year. So it just had its first birthday. Like all great documents, it's undergoing its amendment process, which we always knew that it was going to be a living document, that it was going to have amendments. And that has been borne out to be true. We had 2 rounds of amendments in 2024. In 2025, we'll probably have 3, maybe 4 rounds of amendments. And I'm hopeful that you guys are keeping up with that process and that you're seeing the impact of your comments and your colleagues' comments on how that document is changing over the arc of time. Because I'm very serious when I say that we took y'all's input seriously and tried to incorporate things that you told us and that you suggested. So we've had this document for a year. And section 1.8.5 sets down your provisions. And I'm going to talk about each one of these 4 sections in a fair amount of detail. We're going to go over the Board of Adjustment section. We're going to go over the appeals section. We're going to talk about the special use permit process, and we're going to talk about the variance procedure. Okay? For the 2 of you, Joseph and Karen, whom I don't know, and I'm sorry that I'm happy that we're having a chance to meet tonight, but I don't know the depth of your experience with the UDO and whether or not this is something that you guys have had. Karen, you probably have not had a chance to snuggle up with this document yet, but you'll have that opportunity. The reason I say that is I'm happy to talk more about the structure generally of the Unified Development Ordinance if that would be helpful to you. If not, we can kind of skip the general structure and move right into the most relevant pieces of the Board of Adjustment. So I'll take my lead from you on that. Okay. Did you say 86? If you put another 0 on there, yes. Yeah. Okay. Fantastic. Okay. Very good. Very good. I'm not surprised you haven't read it line by line. Only crazy people would do that, and so that doesn't surprise me. But it is it's voluminous, to say the least. But it's voluminous for a reason. All of the development-related procedures and so forth are embedded in there, along with many, many other things that maybe you don't have to necessarily include in a set of development regulations, but that are very important. Frequently asked questions and, plat certificates and other things. The town may make some changes to the ordinance and try to simplify and reduce some of the bulk by removal of some of those things and moving them to an outside manual. That may happen. But generally speaking, the ordinance that you've got is one that we worked on a process for a couple of years. It's pretty consistent with, kind of best practice, or at least thinking about how to regulate development in North Carolina for a community of this size. And if you have questions about the UDO as we go along, feel free to raise those. Joseph, are you familiar, or have you? About the same boat? Okay. Okay, very good. Okay. Let's talk about the Board of Adjustment in particular. So some of this stuff is set down by state law. There's obviously 5 members on the board, plus 2 kind of alternates. Do you guys understand why we have alternates? I know you 3 know. I'm talking to those 2. So we have alternates in place because sometimes some members need to recuse themselves from a case because they can't be impartial. They have some sort of relationship or some sort of preformed opinion, either about the applicant, the site in question, or the application before them, okay? And so alternates, the thinking is that alternates would be available to step in and support the Board of Adjustment's function in those instances where somebody needs to recuse themselves for reasons of impartiality. Okay, so part of that due process, equal protection element. Quorum is 3. To do any sort of business or make a vote, you need 3 people, right? we have a series of powers and duties set down in the UDO, and I'm going to show that to you in a minute. But you guys have responsibility for three basic provisions, three basic functions of the UDO. We talk about the voting that you use. You're one of the bodies that does vote. There are bodies out there that don't really vote. They might make a recommendation and there might be a vote on that, but you guys are in the position to vote up or down development applications. So people's money and people's livelihoods turn on your decisions. And so it's important that we address conflict of interest and that, impartiality be maintained. Okay. And impartiality means that you don't have a fixed opinion, prior to the hearing. That if you've had any sort of ex parte communication, that be declared, and that you declare that before the hearing takes place. Again, the reason is that if that communication that's taken place outside of the hearing affects your position, your opinion, your judgment about the case, then it's affected your ability to be impartial. And we err on the side of protecting the impartiality of the Board of Adjustment and that there's a clean consideration of the application. I'll ask you guys, as just kind of one Board of Adjustment member to another, I assume you guys, do you talk to one another? And I'm gonna lean on my Durham experience. So in Durham, they ask us not to email one another. We Board of Adjustment members do not spend time talking with each other in any sort of setting or any sort of format. Now, if you see somebody at the grocery store or something like that, that's okay. It's not like you have to run the other way, but any sort of input or interaction among Board of Adjustment members outside of a regular meeting or a special call meeting, either for training or other purposes, is strongly discouraged in my community. I don't know if you guys have that or if that's something that is part of your lore or your tradition. Tell me about that. How do you guys handle that issue?
It's a small town. I'll start with that. So it's hard. I mean, you see people in multiple settings,
Sure.
Memberships on different groups, chambers, Rotary clubs, other civic clubs, those kinds of things.
Right.
Knowing at least 4 people in the room right now that I see once a week, I can say that we've never talked about a case in advance of that case because we know the rules. So I think at least from my perspective, that's how it's been handled. There are some things you talk about and some things you don't. And any case coming before the board, we don't talk about.
Understood.
I know so little about these people. I didn't have anyone's phone number to tell them I was a couple minutes late tonight. So I don't sit on the Rotary. I don't sit on anything. I've not seen these people at the grocery store, and I walk around downtown Clayton, and I haven't so much as seen anyone drive past me.
Okay.
Yeah. I'm not in the club, I guess.
So we're safe with you. We're safe with you no matter what. In my community, it is not uncommon for members of the Board of Adjustment to be contacted, not by applicants, but rather by representatives of neighborhood groups who have an opinion or a position about a case that they know is coming up. That is fairly typical for us. And it is, you should absolutely positively never, ever engage in discussions with members of community groups or anybody else on a case that's pending at any time. And if it does happen, you absolutely positively need to declare during the meeting that you were contacted, whether that was by email, telephone, I was walking down the street, it was in the grocery store, whatever it is or was. It's absolutely vital that you share that information because there has to be the perception and the reality of impartiality and fairness. It is absolutely vital to the efficacy of the decisions that you make that nobody has unfairly influenced you in your thinking. Do you know, does anybody here know how many Board of Adjustment cases go to Superior Court or go through the appeal process? It's hard to know. They don't tell us in Durham, but it happens frequently. We often have decisions that we've made be appealed to Superior Court. And so we've learned kind of
Hey, Chad,
please.
real quick, we had one that was appealed to the Superior Court during COVID, where we were having, the meetings were done via Zoom, and the resultant was that the due process was inhibited because one of the witnesses wasn't able to log on to Zoom, so I had them on my cell phone, and there was an issue with cross-examination of that witness. So that was reverted back to the Board of Adjustment. The court said due process was impacted, so go back, hear the case again, and we had it in person. So that was but that was a unique instance with remote meetings. Just wanted to throw that one in.
Were you guys doing business during COVID? Was that something that you guys did? Oh, man, so were we. And we were using Zoom. Oh, really? Okay. Hopefully we won't find ourselves back in a remote meeting context. Now the state laws have changed and there has to be, some sort of declaration of imminent disaster or other configuration to bring us into remote meetings. But oh my goodness, the level of protection that has to be incorporated into those meetings to be functional and protect due process is really, really remarkable. And we would have all of these things that we would have to read and be very clear about in terms of if we were going to do remote stuff. I'm not going to talk about remote meeting tonight unless you want to. It's very complicated. But ultimately, I just wanted to be sure about this ex parte stuff and impartiality, because that's really, really, really important, that you not talk to, the applicant, that you not talk to somebody who is involved in the case on either side, and that you not talk to each other. It is acceptable for you to speak to staff, okay? That is acceptable. However, your questions with respect to interaction with staff need to be about the staff report, about the process, okay, and not about the degree to which the application does or does not meet the standards that you'll be considering, okay? So,
Chad, so it's, at least during my tenure, I'm the only person that I recall that had recused himself twice, because I was involved in both cases indirectly with the applicants and the projects they were bringing before because of my day job.
right.
So on the second one, it still annoys me to this day, but sitting there, it was an unusual situation where the lead representative for that applicant on their variance request had left literally the employ of the applicant the day they were due here. The meeting got postponed a month. They brought in somebody else, but that person did not have all the relevant information. So I sat in the audience with the answer to the key finding of fact on why they needed the variance, and no one that was representing them actually knew the answer to that. But
That must have been excruciating.
It was. So there's no way around that. Am I correct? That
No.
Even though it was a very simple, straightforward answer, there's no way I could have relayed that before or after to staff, to anyone, correct? Even though I wasn't even representing the
I know.
applicant.
Yeah, I know. Yes. And the answer is no. In Durham, when we have a board member recuse themselves, and I'm not suggesting you do this, I'm just telling you how we do it in Durham. When someone recuses themselves from a case in Durham, they're expected to leave the room. You're not even supposed to stay in the same room because your appearance may impact some of your fellow board members. And so we err on the side of even more sort of recognition of due process and impartiality, and we leave the room. I regularly recuse myself. I often use an attorney, a group of attorneys in Chapel Hill for the code work that I do. And I listen to those guys, and they, I ask them what's legal, what's not. They do a lot of representation in Durham, and when they're before the Board of Adjustment, I recuse myself because I'm impartial. I'm supposed to be listening to their stance about what the law says or how to interpret it, and so when they're before me, I have to step away. And there's nothing wrong with recusing yourself. If you think that you need to recuse yourself, you probably do. And if you're not sure, you can always ask. If there is another member on the board who believes that you cannot be impartial for whatever reason, then any member may call on the chair and make a motion that such and such member recuse themselves or explain their relationship to the applicant or the case at hand, and that can happen.
Yeah, there was no question I needed to recuse myself. I think it was more the frustration of a key fact not being articulated.
Right. Maddening.
And it was
Yeah, for sure. In any case, those 4 check marks on the right-hand side of the screen are the parameters under which your impartiality could be, affected. And so it's the advice that they give us in Durham and the advice that I'll give you is if you even think that there's a conflict, there probably is, and you should at a minimum declare it. And talk about it with the other board members who can help you reach a decision. Yes, you're conflicted, or no, you should be okay. You should always have, and this is a training for staff, you should always have an attorney at your Board of Adjustment meetings. When there is a case, you should have an attorney who is here to represent you, okay? They're not here to represent the town. They're here to represent you. Our Board of Adjustment hearings, there's 3 attorneys from staff, and one of them is there for the Board of Adjustment. One of them is for the city, okay? And because we have a city and a county, there's, one is for the city and one is for the county, but there's always an attorney for the board, okay? And you should always ask questions of them. They're there as a resource to you, okay? All right, so impartiality, very, very important. I know you all have this table committed to memory, pages 48 and 49. These are all of the development review procedures in the UDO. There's a yellow line on the ones where the Board of Adjustment is the decision maker. And so you guys obviously handle a lot of appeals, and anywhere where you see an A, that's an appeal decision that you guys are responsible for. Wherever there's a D, such as the appeal, special use permit, or the variance, you guys are the ones making the decision. You're responsible for action under those applications. And I'll talk about those 3 types of applications in a moment. But this is y'all's responsibility. This is the area where we're relying on you. You see those 2 marks on either sides of the letters, the sort of straight up and down vertical marks. That's a symbol that these are evidentiary hearings, and evidentiary hearings are special. They are quasi-judicial in process. It is like a court, and there are very specific rules about evidence and testimony and standing and how you respond to things. And so we're going to talk about that stuff tonight, probably in more detail than you'd like, but those are important aspects. And y'all are, you're largely the keepers of the evidentiary hearing process. Everything that you do is evidentiary in nature, and you're pretty much the only board who does evidentiary hearings, okay? So you guys are the experts on this. And you need to hold the impartiality more near and dear than everybody else. And you need to hold the understanding about the reasons why the evidentiary hearing process is the way that it is, near and dear, more so than everybody else, okay? So let's talk about some of these procedures. First is the appeals procedure. These are appeals of administrative decisions. Okay, so if Conrad or the engineering director or the public works director or anybody who's employed by the town makes a decision that an applicant wants to appeal, you hear it. okay? You're responsible for hearing those cases. Now, your decisions can also be appealed. Council's decisions can be appealed. In some cases, planning board's decisions could be appealed. You guys do not hear those appeals. Those go to Superior Court for Johnston County, okay? And the reason for that is you cannot be sitting in appeal consideration of a application decision that you've made in some other context. And so let me give you a little bit of background about that. A lot of jurisdictions have a consolidated planning board and board of adjustment. A lot of places do that. For reasons of it's timely, we can't find enough members to sit on both different boards, et cetera, et cetera. In those communities where the planning board has a decision-making role, okay, it is inappropriate for the Board of Adjustment to then hear the appeal of that decision. Why? Because you made the decision in the first place. What's the likelihood that you would come to a similar conclusion seated as the Board of Adjustment? Pretty good chance that you come to the same conclusion. That is a failure of equal protection under the law, right? Because the same body gets to make the decision and then gets to hear the appeal, right? That's not, most of us would consider that to be unfair. And it's that thinking and some of those aspects that gives rise to the fact that some decisions, including appeals of yours, go to the Superior Court instead of to you. All right. There are concerns about maybe the elected officials having undue influence. I know that would never happen in Clayton, but in other places that is a source of confusion and concern. And that's one of the reasons why elected official decisions should also go to Superior Court, and in Clayton do. Okay. Now, when you guys are hearing an appeal, this is the one time where you basically sit as a judge, okay? You guys are in judgment of the application, and there's two kinds of central questions, all right? And it's always going to be one or the other when you're considering an appeal. And this might be a notice of violation appeal. It might be a decision to allow an application to go forward after a prior application was denied. It might be an appeal of a staff decision on a site plan. It could be any one of those things, any aspect. It could be an appeal of a decision by the planning director and determination about what the code says. And your decision will fall into one of the two camps. The staff member in question either erred in interpretation of the UDO or that they erred in determining whether or not the standard in the UDO was met. So it's always, always, always going to be one of those two questions. Every appeal, every time, okay? Because you guys are sitting in judgment as judges on this case, you can reverse the decision that was made by the staff. You can affirm the decision that was made by the staff. You can make an entirely different decision, okay? You have the ability to act as a judge and say, you know, we as the Board of Adjustment find that that notice of violation was improperly levied on this applicant, and we strip that notice of violation. You are no longer in violation, and that's a decision that you guys can make. Or site plan approval. Let's say staff denied a site plan approval. Applicant has appealed. That comes to you. You hear all of the issues. You decide that staff erred in the interpretation of the UDO. You can approve the site plan, okay? So understand that. It's not that it now has to go back to TRC or goes back to the staff. No. You guys, I mean, you can force that if you wish to, or you can decide that site plan's approved, okay? So understand the authority that comes with your responsibility on these appeals. You can reverse, affirm, or modify, okay? And in that modification, you can make an approval. You can act as the decision maker in that case, okay? Does that make sense? Do you guys have questions about that? It's a heavy responsibility, particularly like we've only had a few appeals in Durham, and they're very, very big deals, very hotly contested, and there's always multiple sides with multiple attorneys. And it can be very, very disconcerting to be in that position where, you know, 300 people in the room are all with signs and the shirts and all of that stuff. And, you know, they're trying to, I hope that hasn't happened to you guys. It has happened to us, and it is very, very hard to deal with.
Sorry, Chad. Let me just want to kind of piggyback on what Chad is talking about with appeals. You brought up the notice of violation. So notices of violation is what our code enforcement officers are doing out in the field. Every day they're out there getting citizens to be in compliance with the UDO, with the code of ordinances. But every violation that we send has the opportunity within a certain time frame to be appealed. So that is where you all would be basically the decision maker on an appeal by a citizen that feels that the enforcement is in error or, basically wrong. So that's something just to be aware of, that every day out there, when we're out there enforcing our UDO and our codes, there is that opportunity for appeal. So this would be a great, as well as my decision, staff's decision, code enforcement is also staff. So that's just the context I wanted to share also.
Thanks, Tom.
Are those citizens, so how are the citizens, somebody gets a notice of enforcement, how do they know that they have the ability to appeal it?
So in the UDO, we have that date, off the top of my head, I don't remember, but we let them know in our letters of violation that they have that ability to appeal a decision. Usually what happens is they'll get a notice of violation and there will be a correction, but there might be that instance where there's that argument that they are not in a violation and then they would appeal our decision to the Board of Adjustment.
That appeal has to be filed within 30 days of receipt of the notice of violation or the written decision or whatever triggered the appeal in the first place. And there are other serious questions, which I'll come to in a minute, about whether or not you have the standing to bring an appeal, right? It's one thing if you're a person who's maybe accused of violating the ordinance and you've received a notice of violation. That's pretty clear, cut and dry, that you have standing in that matter. Now, let's just say, for the sake of argument, that somebody approved a site plan next to your neighborhood and you don't like it. Can you, as a neighbor, appeal that decision? Right? That's a very different question. Do I have the standing to appeal that? And I'm happy to tell you that your attorneys and your staff should give you some guidance on that question. However, standing can and does come up in these cases. And I hope that you are never faced with having to reach the decision about who has standing and who doesn't. We are going to talk about it, but it can sometimes fall to you as the Board of Adjustment to make a decision about whether or not somebody who wants to bring an appeal before you can actually do so. I will say this. One of the fundamental kind of building blocks or foundational premises of our legal system is that any decision that is made by a governmental body can be appealed, right, up to the Supreme Court. And that's a fundamental kind of premise of our legal system, that no matter what, I always have another person to go ask. Up into the Supreme Court. And so, the same is very much true at the local land use level. All right? Okay. And I mentioned to you, again, you shouldn't get a lot of appeals because your staff's pretty good. You shouldn't have a lot of these. The ones that you do have can be complicated. They're usually kind of complicated. And you need to take your responsibility in what we do about this appeal very seriously. You can choose to take the action that the decision maker was taking. You can also choose to append the case back down to the decision maker who made the decision in error in the first place. You do have that authority. Now, don't forget that if that does happen, I've come before you, I got a notice of violation, I am appealing it, and you send it back to staff and say, we don't think there's a notice of violation, go figure this out. If I'm, as an applicant, I can then appeal that decision you just made to Superior Court because I don't feel like that I might be treated fairly or that you erred in your interpretation of the rules. So I just want you to understand that even if you do decide to remand, if you decide to remand the decision back to the initial decision maker, that in and of itself is a decision that is appealable to Superior Court. Okay? So you guys can act as the decision maker or you can remand. You can do either one of those. And both of those decisions are appealable to Superior Court. Right? Questions? Special use permits. All right. So the first bullet point reads, certain uses while allowed in the zoning district where proposed, and you can go to UDO section 425 for more information on that. These uses require special scrutiny. It's allowed, but there may be some potential negative impacts from this use type. And what we want, we being the town of Clayton, what we want is a special consideration of this use focused on these potential negative impacts. We want the applicant to come forward and explain how this use is not going to create these negative impacts, or if it does create these negative impacts, how those will be mitigated. Okay, and that is the essence of the special use permit process. Special use permits, uses permitted by special use, are presumptively valid. In other words, they are allowed in the district, okay? And to say no to them if they meet the standards is a violation of the law, all right? Where your role is in the special use permit process is the adjudicators of these potential negative impacts associated with these uses, okay? So if I'm doing an adult business, if I'm doing a group home, if I'm doing some other kind of use that requires a special use permit here in Clayton, if the application comes before you, it's permitted as a special use in the zoning district where it's located, all right? So it's presumptively valid. However, there were considerations or concerns about the negative impacts from this use type on the surroundings. Your case turns, your decision turns on whether or not those things exist, and if they exist, how they've been mitigated, and if that mitigation is sufficient to allow you to approve this use. And that's the decision tree for you on special use permits, okay? Not whether or not it belongs there or not. That's not your decision to make. The elected officials have already made that decision in their approval of your UDO. Your job is to consider that use in that location and the negative externalities that could flow from that and whether or not those are adequately addressed, okay? Now, special use permits require a neighborhood meeting. Section 2.4.4 indicate that applicants who want to do a special use permit need to have a neighborhood meeting first. Now, let's have a word or two about this. And this is, if you get nothing else from tonight, I very much want you to take this under consideration. The decisions that this body makes, okay, need to rest solely on the evidence and testimony that is presented during the hearing, okay? I had a neighborhood meeting. The applicant said XYZ, the sky's purple, the sky's blue, I love zebras, whatever. That is not evidence and testimony that you can rely on during your deliberation. You rely on evidence and testimony that is presented to you during the meeting, okay? Yes, the applicant needs to have a neighborhood meeting. The reason that that provision is in there is to allow the neighbors to know that it's being proposed. Can you turn it down because the neighbors don't like it? That's a question. Do they meet the standard? Do they meet the standards? And if they create negative externalities, have those been sufficiently mitigated? Just because, you know, Conrad's the neighbor and he doesn't like it, that's insufficient for you to deny that use. It is presumptively valid, okay? So in many regards, the neighborhood meeting step, I'm not going to call it a formality, but it has very little impact on the decision trees that you guys use for those cases. They are intended, those neighborhood meetings are intended for the purposes of awareness only, okay? That's what they're there for. And you should not be making decisions based on what's said during a neighborhood meeting, because that's outside of the framework of your evidentiary hearing process, okay? So that's important. Also, there is another step that happens with special use permits, and that is the preparation of a concept plan, okay? This is a site plan that's prepared for this use. It should be very detailed. It should be very clear about what's being proposed and where and why. And that should be considered by the technical review committee before you guys review your special use permit application case, okay? Now, the savvy Board of Adjustment member is going to say, well, Chad, you said the neighborhood meeting couldn't have any influence on our decision-making process. How is it that the technical review committee comments would? And the answer is they wouldn't. Okay? What you have to take on its face is that the TRC has put together this concept plan, and the staff report presents to you concerns that were raised by the TRC during their review. Okay? And that's things that you need to take into consideration. All right? Now, there's a series of 6 review standards for each special use permit. They're set down for you in 2.3.22F. And when we talk about how to do a quasi-judicial process, we'll talk about how you guys go through those, because that's a very, very important step. And everybody's kind of got their own little spin on how they do it. At the end of the day, the final order that you guys prepare, that staff writes up for you, that memorializes your deliberations and the decisions that you reached, that final order needs to, point by point, talk about this application and the degree to which it complied with those 6 review standards, okay? And y'all's goal should be to deliberate on each and every one of those review criteria each and every time, okay? And sometimes, you know, we get better at that with practice. In Durham, we've had a lot of practice, and we've gotten a lot better over the last 3 or 4 years at going through each of the applicable review criteria. Is it met? And if not, why? Okay? And that's vital to the ability for your decision to stand if somebody appeals your decision to Superior Court. If the court finds that you didn't base your decision on the review criteria, guess what? You lose. And either it comes back to the town or it goes on to the next appeal court and there's money involved and it's not a good scene. Okay, so I just can't stress enough that you need to go through each and every review criteria. As you're sitting at cases and you're not feeling like you're talking thoroughly through each review criteria, it's your responsibility as a board member to say, hey, wait a minute, let's go back to number 2. Are we good with, you know, review criteria number 2? Did he meet that? Yeah. Okay, great. I mean, that's kind of how it feels when you're going through this stuff. And we're at a point in Durham where we actually just sit down and say, all right, number 1, who wants to take it? And we actually delegate different board members to take responsibility for, you're going to do number 1, you're going to do number 2, you're going to do number 3. And so we just assign that so that the person is, you know, there's at least one person who's paying attention to that particular review criteria that they're responsible for answering. Okay? So that's something to think about. It's a good way to kind of spread out the responsibility of the review case. One more word on the conditions of approval, because these are important and they're becoming more so. Okay. Conditions of approval are ways that you condition an application. We think, Chad, that your proposed convenience store is okay. It looks like you've mitigated traffic. It looks like you've addressed property value. We're very concerned about the lighting, and therefore we want to condition your approval that you turn all of the outdoor lights off at 12 a.m. every night. Now, we can argue for hours about whether or not that's a lawful condition or a reasonable condition. It is closely tied to the application, all right? And your conditions need to flow from concerns that you have about the application. This discussion isn't so much about the efficacy of conditions, but rather to be sure of 2 or 3 things. Number 1, the applicant has to agree to them, okay? And the applicant has to agree to them in writing. Okay, before your final order is issued, you need to have a piece of paper that lists the conditions, and the applicant needs to sign off on those. If you fail to do that, you may not enforce those conditions. Okay, so it's very, very important. Next thing I want to say about conditions is they have to be lawful. right? There are a handful of conditions out there that even the federal statutes step in and say, and when I say them, you'll be like, oh, of course, these are federal laws, but believe it or not, there are local governments who sometimes mess this up. You can't condition things based on somebody's age, their race, their gender, their income, what they do for a living. Those kinds of conditions are violations of federal law. All right, so just keep that in mind, that there's some guardrails for you on conditions, and your attorney who's before you will, when they hear that somebody's trying to do a condition that might be outside the bounds of the law, they'll speak up for sure. But what's important is that you understand those conditions need to be in direct relation to the proposed use and proportional in the level of impact that they're trying to address. They can't be illegal. And they need to be in writing, and they have to be approved. Now, pro tip for you, when we're deliberating, all right, and we're ready to call the question on a case, and we've got conditions in the motion, right, that are outside of the normal UDO standards, we stop and we say, okay, Ruth, do you agree with these conditions as we've discussed? And we wait until that applicant comes up and comes to the podium and stands here and says, I agree with the conditions that you've stated, all right? We still make them sign a piece of paper that they, agree to those conditions, but we do this before we vote, okay? So just plant that seed for you guys as you're thinking about how to do this going forward, all right? Questions about special use permits? About the right amount of detail, too detailed, move faster, move slower, helpful? Do you know all this already? So give me a sign. Okay. How are we doing on time? Okay. God. I don't know how you guys stand it. All right, variance. Strict application of the UDO standards creates an undue and unique hardship for a landowner, and the landowner seeks relief. Undue, unique. It's a hardship that nobody else shares. It's unique. It's not fair. It's undue, okay? Undue and unique. If you don't have that, you don't get a variance. If everybody has this hardship, it's not unique, all right? If this is a standard that we apply to everybody in your general situation, then it's not undue. All right? So it's very, very important to remember those two words. It has to be a hardship, it has to be undue, and it has to be unique. If you don't pass those tests, you don't get a variance. Okay? There's 4 different kinds of variance applications, and I'm sorry that there are so many, but there are so because there's so many different things that we have to deal with now in modern land use law. Your regular zoning subdivision variances, right? I need to deviate from this setback. I need a different height. I need a different number of parking spaces, or I need a different landscaping configuration or sign or whatever. Zoning subdivision. There's also flood hazard overlay variances. I need a deviation from this elevation height. I need a deviation from the ability to locate my building within, the floodway. Those kinds of standards you guys consider. Stormwater. I need relief from this storm treatment standard. I need relief from this expectation of sediment load. I need relief from some technical standard. You guys hear those too, okay? And then finally, the water supply watershed standards, which control density and impervious surface, and to a lesser extent, what you can do inside riparian buffers, okay? Those are the water supply watershed standards. So, 4 different kinds of variance applications. The process is always the same. The standards are different for each of those 4 different types of variances. And those review criteria and standards are set down for you, in section 2329. Okay, so that's there for you. I assume you guys probably haven't gotten a lot of these kinds of funky stormwater, water supply, watershed variances. Okay. Know that there are some state agencies involved in this too, particularly with respect to water supply watershed. The EMC, the Environmental Management Commission, is responsible for making decisions on major water supply watershed variances, but you are still expected to hear them and make a decision. And that record goes on to the Environmental Management Commission for them to make the ultimate decision about those kinds of variances. And that's bigger stuff that's happening primarily in riparian buffers, is generally what those variances are. Okay. Like special use permits, variances require neighborhood meetings. But we've talked about, that's for purposes of notice, for purposes of awareness. It's not necessarily because you're expecting some kind of criterion or some kind of evaluation metric to flow from those neighborhood meetings. And you should not be relying on evidence and testimony that are presented solely at those neighborhood meetings because it's outside of your forum, okay? 4 findings of fact to grant the variance, and I'm not going to repeat them to you. I know you know what they are. Obviously, there's a hardship, and that it's unique and that it's undue are absolutely important. I often advocate for another criterion, which is that the variance requested is the minimum necessary to allow me to move forward with my proposal. I don't think that we ended up leaving that in your UDO, but that's certainly something to think about if you guys want to do that. It gives you more authority in making decisions about what's being requested. So let me give you an example. Let's say for the sake of argument that somebody needs a setback variance and the building that they built their building and there was an accident or there was stone on the property or whatever. And so they needed to encroach into the setback by 6 inches. And nobody could have predicted it. It's fair. It's not necessarily a malice driven application. It's in reaction to what happened. But, okay, it is number 5, good. Let's say this happened and there's stone on the property and I need to encroach into the setback by 6 inches. But I bring you a variance and I want to increase into the setback by 6 feet or 10 feet, all right? You have in your review criteria the ability to say, well, gee, Chad, I see that, the site work that you've prepared or the survey that you've got before us that's been entered into evidence and testimony indicates that you need to be over the setback line by 6 inches. You're asking for 10 feet. Why? Explain that. Explain why you need that greater variance, because certainly all you needed to be made whole was 6 inches, right? So why are you asking for 10 feet? That's a valid question for you to pose, okay? Also, you guys hear reasonable accommodations, and you probably haven't heard too many of those. And so in the United States, we have the Fair Housing Act, and the Fair Housing Act says that no local government law can deprive someone of housing that is made available to other people. Okay, again, remember that sort of equal protection kind of concept. The Fair Housing Act says we can't deny people housing. The reasonable accommodation process is in place to allow people to request deviations from standards based on fair housing considerations. So, what does that mean? That could mean something like, I am physically disabled and I need to have some sort of accommodation to get into or out of my house, like a ramp or an elevator or something that might not be allowed because of the zoning rules in place, the setback requirements, et cetera. Okay, so that's one of the things we see. In Durham, we've had 2 cases where people needed therapeutic pools in order to receive treatment for their conditions. And those pools needed to encroach or were found in locations where pools generally weren't permitted. And the reasonable accommodation procedure was what they used to be able to enjoy their housing and be protected under the Fair Housing Act. But it doesn't stop there, okay? Another perfectly legitimate application of a reasonable accommodation standard might be a group home separation requirement. Remember that group homes are required to be a half mile from one another, okay? Now, you might find yourself someday presented with a firm that comes before you who can't meet the separation requirement for whatever reason, okay? And it's going to be necessary for you to consider that application under the reasonable accommodation doctrine, all right? So there's numerous different ways. Sure, question.
About the reasonable accommodations, generally whenever a variance is granted, it's in perpetuity, right? And so whenever someone uses this rule to be granted a variance based on a reasonable accommodation, say a therapeutic pool or a wheelchair ramp that doesn't meet setback requirements, does it extend past the person living in that domicile?
What a fabulous question. Absolutely fabulous. Variances run with the land. There's only one kind of development approval in the state of North Carolina that runs with the person, and that is approval for outdoor advertising. Runs with the permit applicant, not with the land. The question that you asked, does the approval for that pool or that encroachment run with the land? Absolutely it does. So good question. Have you guys had reasonable accommodation applications yet? Okay. A couple of pro tips on those. The reasonable accommodation turns on the question of, I have a condition, I have a disability, I have some sort of personal circumstance that necessitates my need to request a deviation. In Durham, we do not get into the business of adjudicating whether we think their condition is suitable or significant enough to warrant the request. If somebody says they've got a condition, we take them at their word. Now, some people submit doctor's notes, doctor's letters, evidence in that form as a rational, a justification for the request. Generally speaking, we do not require that. If someone wants to provide it, we will accept it into evidence, okay? But we do not call for it because there's HIPAA violations with respect to your medical condition, and you can't force somebody to violate HIPAA to meet your standards. So, as a practical matter, if somebody says, I need a reasonable accommodation for a condition I have, it's okay for you to say, what condition is that? But it's not okay for you to say, I don't think that condition warrants a reasonable accommodation, or I need to see more proof that you have this condition. Could you make those requests? Maybe. Should you make those requests is a different matter. In Durham, we do not. You may decide that you wish to, you may decide that you want to take somebody at their word, and that'll be a decision for y'all, your attorney and your elected officials. In Durham, we don't require that, okay? Okay.
I have a question.
Please.
So can we enter into what we call the interactive process in the HR world, where we don't discuss the medical diagnosis and don't question that? It's more if they're asking for a pool, well, are there other options? And it's called the negotiation, it's called the interactive process, where you work through to find an appropriate solution.
It's a great question. I'm putting on my Durham hat now, and I'm sort of putting myself in that place where we're in session, we're seated, and somebody says, I need a reasonable accommodation, I've got this condition, and I need a pool. I don't know that, I think from the, and don't take this the wrong way, but I think from the optics of the situation, we probably would not go down the road of, well, is that method of therapy adequate, appropriate? Do we think that we agree or not? Most of the time when we have somebody with a reasonable accommodation, they have evidence from their doctor that says this person needs X. And we say, okay. And we make a decision about, does that having that X equal an undue or unique hardship, right? Or does it have may it have a negative impact on property values or public safety? And if it does, then we might enter into a little bit of deeper discussion. But that honestly has not happened yet. We generally say, okay, because the folks that we've seen who've come to us for reasonable accommodations, they need it. They wouldn't be opening themselves up to this process if they didn't need it.
Yeah, and I wouldn't question whether they needed it or not. If they wanted the ramp to look like this, could we say, well, can it look like that? I don't know.
Probably. You probably could have some discussions about the manifestation of that. I think that doesn't turn on the question of do you need it or not. It turns on the question of how do we configure it, which is, I think probably a little bit more comfortable. And I'll be honest with you, I mean, we rely on our attorneys. We look over and say, well, what do you think about this? I mean, that's not uncommon for us to get their read, mid-hearing. I have stopped applicants and said, 5-minute recess, I need to go talk to the attorney. That happens not all the time, but it's not that uncommon. And you should do that because that's why they're there, is to help you so you don't do something wrong. Okay? Okay. Conditions of approval, just like with the others, right? And I think, yep, that's it. Take 5 minutes, get some of this delicious food before we roll into quasi-judicial process, which is really riveting stuff. It's up to you. Okay. So,
Chair, why don't we take a quick 5-minute break and stretch up? There's some snacks. Make sure everyone's well fed and
what
has a
time do we
drink.
reconvene?
It is 7:15 right now, Chair. So what time would you like us to come back?
Very
7:20.
7:25. Thank you.
Thank you.
That's right. He better know this stuff. All right, very good, sir. Thank you. I think we're going to try to get you guys out of here by 8 p.m. So we're going to talk through the quasi-judicial process, see where we are. In thinking about these hypothetical cases, we may decide that you guys want to take a little bit of time. The reason that I'm saying this is one of the things that we do when we're in Durham is we keep notes about, gosh, we'd really like to talk about this case at our next training session. So, and then we go back over it and we're like, okay, well, remember we said this or we did that, or, you know, the attorneys come in and they say, you did this wrong, you did that wrong, you should have done this instead or whatever. So I'm saying this as you guys over the next few months, if you decide that you want to talk about hypotheticals at some point and you go through some cases and you have one that you're like, I'd really like to talk about that, keep a note and then we'll honor that and go through that case with you and talk about it. So.
If we have a long gap where, we've gone months without any cases, it's like anything else. If you get a little rusty.
Yeah.
And I would find it interesting to then, set aside one of our meetings and have a couple of, you say hypotheticals, I think case studies, that kind of thing.
Yes.
And either use something you bring that you had in Durham and maybe go back and pick one of something that's gone through here.
Yeah.
I'd find that valuable just to stay tuned up, if nothing
Absolutely.
else.
Absolutely.
I mean, if we're doing a case, if we've got cases every month, it's different because you're living.
Right.
So.
Right.
That's,
right.
again, my own, speaking only for myself.
Okay. Well, I hope that you guys don't have the caseload that we have in Durham. We have, usually 6 or 7 every month. In fact, we're meeting just 11 times a year, and this 2025 is the first time we're going to full on 12 meetings. So we have enough material to, do a lot. And some days, we might have an 8-hour day. Which is crazy. But anyway.
I think from the writing of our UDO that we gave a lot of those decisions to staff. So we've written ourselves out of a job in many cases.
And it's okay that you don't have a lot of cases. That's actually all right. If you don't have a lot of cases, maybe that's not a bad thing. So, okay. I want to talk about the quasi-judicial process. And while this stuff is dry, it's also really, really important. So we'll move through this stuff fairly quickly and honor y'all's time by having you out here at 8 o'clock. Okay. If we come to 8 and I'm not done, throw something at me and we'll stop. Okay. Right. All right, so 2 elements in any quasi-judicial decision-making process. Remember, it's quasi-judicial. It is like a judge. It is of a court nature. And so you have findings of fact and then the exercise of judgment and discretion. Okay, so you guys are applying your judgment and discretion to a set of facts that are presented before you in the case. Okay, you're unique in that. Okay. While the town council gets to apply its discretion to rezoning cases, you guys get to apply your discretion to things that aren't legislative in nature, but rather are more standard based. And that's unique in the land use rubric. Okay. Now, I'm going to stay on this slide for a minute or two. This is the classic process that we use to go through the evidentiary hearing aspect. Okay. And public notice obviously is done by the staff. That's not anything that you guys do. Staff is supposed to prepare a staff report, okay, and deliver those materials to the applicant, to you, to anybody who has requested it. Okay. Generally speaking, there are no statutory timeframes associated with that. In Durham, it's about a week, okay? That's about what we get. We used to get paper stuff, and now everything we get is just digital, and we download it ourselves. I don't know how you guys roll. We would be getting packets in the mail that were 2 inches thick, and it was like, why are we doing this? Let's just go to digital, and so we do digital now. I wish that all of our Board of Adjustment members had access to a computer or something like that. Some of them don't, and it makes it harder for them, but that's more of an equity question. you guys, the room that we meet in, we have a dais, but it's nothing like this, and we don't have little computer screens that show what you guys are looking at. So you guys are ahead of us. You're in better threads than what we've got. So feel good about that. But anyway, those materials usually come about a week or so before the case. Now, hearing day, it's time to come in and sit and start. There's a formal opening to the hearing, and you roll through the agenda before you come to the cases, okay? Generally speaking, and I'm going to kind of bleed into my best practices a little bit here, but I'm also just kind of want to cover some of the things that we normally do. I have a prefatory statement that I read at the beginning of every meeting that explains that this is a quasi-judicial process and people's right of appeal and standing and notice and all of these things, and I read it every single time. Something else I do before every single case is I say, this is a special use permit, this is an appeal, this is a variance. Section blah, blah, blah of the UDO sets down the standards that we will use in making this decision. And I read those criteria into the record at the front of every single case, okay? And I do that for two reasons. One is to get it on the record, and two, to remind the people in the audience that we're going to be making our decision based on this 6 or 7 things. So don't come up here and tell me about, your brother or your problems with, somebody down the street or some issue you had 10 years ago. We're here to talk about the criteria that are in the book. That's what we need to talk about. First thing that should be happening is the first thing that needs to happen with every case is that you need to administer the oath, okay? So everybody who is going to speak in a case needs to raise the right hand, I swear to tell the truth, the whole truth, all that. That should be done for everybody who speaks, okay? Including staff, all right? Staff should be standing up and taking the oath for every case, okay? Attorneys do not take the oath because they're considered to always be under oath, okay? Talk about that offline, but attorneys don't take the oath. So everybody does the oath. We also call the seating. And what I mean by that is our Board of Adjustment is 10 people. You guys are 5 people. There's 10 of us, and sometimes people need to recuse, sometimes people aren't there. We call into the record who's seated for the case, and we identify the alternate. We have a series of alternates, and it's necessary for us to identify which alternate was there, because some cases get continued. Okay, and then you're in the situation where you're having to remember who was seated for the case, because they're the ones who are supposed to be seated for the continuance of the case. Okay, so it's just a good practice to always call the seating up front. Then comes the presentation by staff. Staff should give you a short presentation that's based on the staff report that you've received. At that point, it goes over to the applicant. The applicant comes up and makes their presentation and provides their evidence, starting with the person who is running the application, whether that's the applicant themselves or the attorney, okay? They are the pinnacle, the point person for the application, and they speak first. It's also their responsibility to coordinate and control the flow of their people who are coming up to provide testimony for them. Their site engineer who's done the engineering work, their traffic engineer who's going to go over their TIA, their property appraiser who's going to talk about the property appraisal report, okay, and whomever else. So that's their responsibility. They present all of their evidence, okay? Everybody goes on the applicant's side. We typically try to wait until each person the applicant brings up to ask questions. We do ask the pinnacle person, the first person, any questions we have up front when they've said, hi, my name's Chad Meadows, I'm here for a variance, you should approve this because it's the greatest thing since sliced bread. I say, does anybody have any questions for the applicant? And that's the clue for the board members who might have concerns about this particular case. Gee, I'm really concerned about traffic. I'm really concerned about the building height. I'm concerned about this piece of the property appraisal report. Okay, that's the opportunity for the board to direct those questions to the point person to focus on, okay, the 16 other people that we brought, we don't need to bring them up. We only need to bring the traffic guy, the parking guy, and the appraisal guy. All right, so we're trying to control the meeting by giving the applicant a heads up about the questions that we're going to ask. Okay? Applicant and all of their people present. Then the opposition speaks. Okay? So, oh, and one other thing I'll mention. I always ask first for those who are in support of the application. All right? Everybody who's in support, when the applicant finishes, thank you, applicant. At this point, it would be appropriate to hear from the people who are in support of the application. Is there anyone here to speak today who's in support of the application? And they come forward. Okay? If and when you guys want it, we can talk during these hypotheticals about how to manage that. I generally don't time people unless there's 50 people in the room. If there's 50 people in the room, I put a 3-minute time limit on all testimony, okay? And we also always ask, hey guys, I see everybody's wearing the shirts from, XYZ neighborhood. Guess what? We do not want to hear from each and every one of you. We see that you're here. Please stand up. We'll recognize and count you. Designate a representative and have one person be here to provide that testimony. If there's more than 50 people here, we will give that person 6 minutes, okay? But we're not going to take testimony from anybody else, from your group, okay? You guys probably don't need to worry that much about that. You probably aren't at this point where you have these kinds of hearings, but it's not uncommon for us to have, 200 residents come out and be angry and signs and shirts and all that stuff and just come up and say the same thing over and over and over and over and 6 hours later, so we try to manage that. So the applicant has spoken. Everyone who is in favor has spoken. Now it's time for the opposition. Okay, so now I'm going to be appropriate to call for the people who are in opposition to this application to come forward and speak. Now, they get to talk, and they can also ask, I heard Conrad say something, and I'd like to ask, Conrad being a representative of the applicants, I heard Conrad say something, I'd like to ask Conrad to come up and answer this question. And Conrad comes up, and the two stand at the podium, and the opposition person asks the applicant's representative a question or questions. There's cross-examination going on right then, okay? The important thing to remember is this, is that every single person who speaks in opposition, the applicant has an opportunity to come up and confront them directly while they're speaking, so that and the applicant gets to cross-examine oppositional witnesses, okay? They'll know that. If they don't have an attorney and there's somebody in opposition, you might help that applicant by saying, applicant, that you have the opportunity, if you have questions for this person who's just spoken in opposition, you may ask them questions if you wish. And they may say, yes, I wish to, or I don't want to, whatever. But you need to make sure that that opportunity is expressed on the record, okay? So anybody in opposition, applicant has a chance to cross-examine them, mention into the record that that opportunity was afforded.
Thank you for allowing me to ask a question. So in quasi-judicial hearings, I believe there is an opportunity for a heated debate, especially when you're allowing, and I mean, I'm certainly for due process, right? But certainly when you're allowing a back and forth, right, like this. Is there ever a time at which you all in the past have had to have a law enforcement present in a hearing? And at what point are those types of decisions made for the safety of the participants in the hearing?
That's a great question. When we have meetings that we think are going to be contentious, we actually do have them in the council chamber, which is downstairs. Our normal meetings are upstairs, kind of like where we met with the UDO, in those kinds of rooms is usually where we have our meetings. We don't have law enforcement there. Downstairs, there's law enforcement at the door, okay, every time. we have not had to have law enforcement come into any meetings in my experience. That's not happened. Most people do try to be on pretty good behavior. As the chair, if you see something starting to get sideways and people starting to get heated and upset, absolutely, positively, do you have a gavel? Okay. 5-minute recess every time. And eventually you'll get them trained. Okay, if this happens more than once during a hearing and they see that you're going to bang that gavel and make them wait 5 or 10 minutes, they'll stop being such bad children, bad behaviored people. But that's your responsibility. You're running the meeting. And if it gets out of hand, it's your responsibility to stop it. If you've called for a pause, if you've basically said we're standing down, we're not in open session, and people refuse or want to continue to provide evidence before you, and you've asked them to sit down and they won't, call law enforcement and probably continue the meeting is probably what I would do. I would say we're going to, I'll entertain a motion for continuance to a date certain, okay? Because life's too short for that stuff. Okay, great question. Okay, applicant spoke, in favor spoke, opposition spoke. We had the opportunity for cross-examination by the applicant that's recognized in the record. We closed the hearing. Okay, no more testimony. And I know they're sitting back there. I just want to, but I got to. No, close the hearing. Thank you. And I just encourage you to stick with that policy. It's absolutely fine for you to say, we're preparing to close the hearing. Is there anybody else who has anything else to say? You can ask that question if you want to or not. But generally speaking, when the public hearing is closed, public hearing is closed. And we do not take more testimony. Okay?
Chad,
Yes.
somebody, so everybody's taken the oath. Please stand up if you plan to testify.
Yes.
Somebody
Didn't take the oath.
didn't take the oath.
Came in late.
Came in late, whatever.
You need to administer the oath to them before they speak.
Okay.
Absolutely. And we have actually gone back after somebody spoke and we're like, did they take the oath? No, I don't think they did. We make them stand up and take the oath again, even after they've provided testimony. Absolutely. Yes. Yes. Okay. You've closed the hearing. We wait to get a staff recommendation until we've closed the public hearing. That's a personal choice. You guys could do it that way or you could do it a different way. Generally speaking, staff should not be giving you a recommendation on an appeal. Okay? Because the staff's opinion. They were the ones who made it in the first place. They should not be giving you a recommendation on appeals. In Durham, staff does not give us recommendations on variances. They will on special use cases, but they will not on variances. And they should not on appeals. I don't know how you guys run your ship, whatever. But we wait to get the staff recommendation until the hearing's closed. That's just how we do it. If there's no magic. You can do it, when the staff has finished their presentation, or you can wait. We like to wait because we at least like to have the illusion that we haven't made up our minds before we, come into, I'm obviously being facetious. We're all, neutral here, but we don't want the staff recommendation to prejudice us. And that's why we wait. Okay. Then comes deliberation. And that is the most important part. Let me ask you guys a question. When you guys have a case and you're deliberating, how long do you spend deliberating? Okay. How long? Okay. Do you guys feel like that's a good process, an easy process, or is it one that's labored and there's a lot of quiet time and waiting for people to talk?
I know on occasion when we've had some tough cases, when you got a 5,000 square foot building that's been built, and if you say no, it's got to come down.
Right.
That was one that came to mind. But it has gotten quiet up here. It's hard to believe these guys would be quiet. It's been quiet, and you just somebody needs to say something.
Right.
We do. I guess say more than not, and it's really kind of that's just what we do now. We take each finding. I will read each finding and generate discussion.
Okay. Good.
It seems to work.
Good. Fantastic. Fantastic.
And
Try designated, try that sometime. See how that works for you. Okay, Jim, you're going to do number 2. All right, Rebecca, you're responsible for number 3. Karen, you're going to do number 4. Just, before you guys open the case, just, make that dole out that responsibility. If you do that a few times. So my folks were very timid and they didn't want to talk. And we're like, oh, gosh, I hope he doesn't call on me. And we would sit in silence for 5 minutes. And I'm like, we can't continue to do this. So we're big on deliberation. We're big on it. And even to the point where we're calling on people and we're like, okay, let's have a conversation here. Because it just wasn't in our traditions in Durham. And, your deliberation is going to give you guys a better outcome. Everybody has something to say. Everybody's got a good idea. And 9 times out of 10, what comes out of somebody, everybody else is like, I was thinking the exact same thing, right? But they didn't want to mention it because they felt like they didn't understand or that people would think they were dumb or something like that. It's just stupid reasons. Building your rapport together so that you're comfortable together is one of the best things that you can do, okay? And while we're not supposed to email one another, I'm going to let you in a little secret of something that I do in Durham, which is every quarter we go out together and we do not talk about Board of Adjustment business, and staff doesn't like it, but we do it anyway because it gives us the ability to build a rapport. So when we're deliberating, we don't have all of that mess about, well, I don't know these people and they don't know me, and what if they think I'm weird or dumb or what, they'll think that that's a bad question. We don't have that problem because we get together and spend time as human beings together outside of the forum, and that helps us be better Board of Adjustment members. So I make that suggestion to you. After you've deliberated, you reach your decision, and then there's the final order. Staff should write the final order for you. Marty, you should be considering that order as a group the next meeting. If you're not doing that, you should be doing it that way. Everybody should read the order, and everybody should have an opportunity to give staff comments on the order, and that should happen before you sign it.
Chad,
Okay.
I got a question for you in terms of the process when you were bringing up the conditions of approval and they had to sign it. Is it appropriate to so the board would vote on it, but the order is done at the second meeting? Can staff have those conditions signed? When do we have to do it at the meeting, or can we do it after the vote for the first meeting and then we get the applicant to sign the
Right.
conditions?
Right.
And then the board will have those signed conditions.
Here's how it works as a practical matter in my experience. So we deliberate, we decide we want to have conditions. We discuss those conditions, often with our attorney, in session during deliberation. The condition is embodied in a motion. Okay, before the question is called on the motion, we ask the applicant, these conditions have been attached to a motion for, approval of your case. All right. Do you support these? And we ask them to come up and affirmatively, yes, no. Oftentimes, there's discussion and back and forth about the conditions between the board, the applicant, and the attorneys and the staff. Oh, we can't do that because we can't enforce it, or, oh, I'm not prepared to do that, I might do this instead. There's still negotiation of condition at that time. The conditions are embodied in the motion. Very, very important because that's in the record. Okay. Staff uses the record to write out the order that sets down in writing the conditions. Now, one of the things that happens after we've voted is staff walks over to the applicant during that meeting and says, okay, Conrad, the motion said this condition and that condition and the other condition. I need you to sign right here. Okay? And the applicant signs. Okay? That's not the final order, which they'll have to sign again. But we do obtain signature authorization before that person leaves. Okay?
So Chad, just so I'm clear, the second meeting, the meeting after you vote, when you're considering the order.
Yes.
Do you guys vote?
Yes,
Okay,
absolutely
okay.
we do. There is a motion and a second and a question called, and everybody weighs in. So we deliberate on the order, and then there's a motion and a second. So our meetings have two main pieces, our cases and then our orders from the prior meeting. And sometimes orders take 2 or 3 meetings to get back to us.
And the case is not settled until the order is approved, right?
The case is not settled until the order is delivered.
Gotcha.
Okay? All right. How are we doing? Oh, man. All right. We'll move through some of this stuff quickly. You guys have the presentation, so I encourage you to look at this. Standing is the right to participate and provide testimony in the quasi-judicial hearing. These 4 bullets, these little circular open bullets, are right out of the statutes. Those are the people who have standing: the applicant, the landowner, lessee, or contract purchaser, if different from the applicant. Any person who's going to suffer special damages as a result of the decision. I'm going to lose money. I'm going to be affected by pollution. I'm going to be affected by noise, whatever, okay? It is their responsibility, not yours, not staff's. It's their responsibility to demonstrate that they are subject to special damages. And you may be called upon someday to adjudicate whether or not you agree that they might be subject to that or not. You should be, what's the word I'm looking for? You should recognize that if people are here, that they're probably halfway to having standing, okay? But sometimes, I don't just think, though, that because somebody showed up, they get standing. Sometimes you have to make a decision about that. And 9 times out of 10, if there's somebody there who shouldn't have standing, the applicant's going to be like, wait a minute, how come Bob's here? He lives 2 miles away, And so that sort of thing generally kind of comes up on its own. The last thing I'll mention to you is this, because it is relevant. Any association of people who feel like they would suffer special damages also has standing. So let me give you an example of one that we had in Durham. We had a case coming before us where there was an additional phase to a subdivision. And the additional phase to the subdivision was actually going to alter this pond that had been made, okay? And the neighborhood loved the pond. Okay, they loved it. And it had no stormwater function. It did not have any sort of protection under 404 or 401. And the proposed subdivision was going to have some impact on the pond. This neighborhood formed an association, Save Our Pond, and tried to come up and say, we have standing to participate in this matter. And we said, no, you don't, because you were formed in response to this matter. You didn't pre-exist it, okay? And that's right out of the statutes. If there's a neighborhood association in place, you've got a homeowners association. I assume you get that sort of thing where HOA people show up and say, we're next door and we're the HOA. That's legitimate and they have standing, okay? But if I come up and I say, I was formed to oppose this application that's before you today, you don't get standing. Okay, so it's important you understand that distinction. Any association, provided it was not created in response to the application being considered, all right? Standing, very important. Hopefully you never have to deal with it too much. Burden of proof, I cannot say this enough. Whose burden? Who carries the burden? Applicant carries the burden. Substantial, material, competent evidence. If it's anything other than those, I don't care. I don't want to hear it. Substantial. The amount of evidence that's been given to me is enough for me to make the decision. It's relevant, it's reasonably related, it's logically connected, and it came from somebody who a reasonable mind would agree with them, with what they're saying. Those are the tests. If some evidence presented before you isn't substantial, material, competent, you may disregard it. If you're thinking as an individual board member, gee, I think that stuff Chad said is not material, you can raise that and see how the rest of the board feels about it. And if as a group you guys decide, yeah, you're right, gosh, that Chad guy, he's crazy, we're not going to accept that as material evidence, then you can do that and that can be stricken from the record, okay? Mm-hmm. Right. There are two, great question, and two great questions. The statutes are very clear about two things. Traffic and property value. Those are the two things that you must be an expert witness to talk about. And an expert witness means I am a PE or an engineer, or I have special training with certification, I have a license. And my licensure is reviewed and renewed by the state of North Carolina in some way or another, okay? So those are the two aspects. As a I can't come up as a planner and say, well, that's going to have a negative impact on property value. I mean, I can say that, but what you can say is, are you an appraiser? And I say no. And you say, well, thank you very much, go sit down, because we're not able to accept your testimony and evidence on this.
Outside of traffic, any general engineering questions, they're not, they don't require an engineer?
That's correct. There's two lines of question where you must have expert witness testimony. This is a great question. And that's transportation impact analysis, traffic analysis, and property value, okay? To take testimony on either of those topics, it can only come from an expert. Now, can somebody come up and say, I live down the street, I've seen that intersection, there are accidents. I saw one last week. So can somebody, can you accept that as testimony? The answer is yes. Okay, but can that person stand up and say, I know that when Chad builds that subdivision, there's going to be way more cars on the street. And I saw from Conrad's subdivision that there are 14 new cars and Chad's is going to make 28. And I just know that's going to be true. And you're going to say, are you a traffic engineer? And they're going to say no. And you're going to say, go sit down. Thank you. Because that's not competent evidence. Okay. Does that make sense? Two things: traffic, property value. The other stuff, you do not have to be an expert. It helps if you are, but you don't have to be.
Okay, I learned something then, and I'm going with what you're saying. I just thought everything we've been told had to be expert testimony.
Yeah, I thought so too.
I mean, I participated in dozens, and I've always thought everything I was saying had to be done by, it could be engineering-wise, it could be stormwater, it could be a number of things, but I always thought everything had to be expert testimony.
You can be tendered as an expert witness by an applicant, okay? And that testimony that you give as an expert is supposed to have extra weight, okay? But those two subject matters are the only ones that you must be an expert in order to testify. Okay, so I can be an expert on stormwater and provide evidence, but there's no requirement that I be a stormwater engineer to talk about stormwater engineering. In order to talk about property values, I must be a certified appraiser, certified to do business in the state of North Carolina. I must be. Okay? Okay. Yep, we're coming up to 8 o'clock. 5 minutes over or stop, because we can always come back to this. What do you guys want to do? What's your pleasure? See, you knew I wasn't going to stop at 8, right? Come on. All right, 5 minutes. Hearsay. Person needs to be present at a hearing to present testimony, okay? Use of letters or proxy statements are generally not accepted as evidence. Oh, I've got a letter from my neighbor, Larry. He couldn't make it because, his dog has cancer. Thank you, but if Larry's not here, we can't accept the testimony. Why? Because he can't be cross-examined, okay? Technical reports and analyses from government officials can be presented. They're treated a little bit differently than in-person hearsay. All right. Expert testimony. We talked a little bit about this. The expert witness testimony has more credibility than a layperson. Opinion evidence should only be offered by a person who is qualified as an expert witness. In my opinion, this development is not going to create a traffic problem. Okay, are you a transportation engineer? I am. Then your opinion matters. In my opinion, this development's going to create a lot of traffic. Are you a transportation engineer? No, I'm not. Well, your opinion doesn't matter. Thank you. You have to present evidence of your credentials for analysis and approval by the chair, okay? So be clear on that. When you've got somebody standing at this podium saying, I'd like to bring forward Chad, my expert witness, that person needs to come and give you their resume and their licensure or their certification numbers, okay? And if they can't do that, you need to continue the meeting or disregard them as an expert, okay? You have to be able to provide evidence into the record that you are an expert witness, right? Okay. We already talked about property values and traffic safety impacts, all right? A couple other things I'll focus on: deliberating, determine the facts of the case, apply the standards to the facts, and reach a decision only after step 2, okay? So what are the facts? And we've applied the standards to the facts. Always, always, always ask yourself, did the applicant meet their burden of proof? Not, oh, he seems really nice, or oh, he's had such a hard time, or oh, I really like redheaded guys. Did the applicant meet their burden of proof, yes or no? And if the answer is no, you have to say no. And the facts that you've gotten on the record, do they support this conclusion? And you should always be checking in with yourself every single time you're ready to say, yep, I'm ready to vote on this. Those 2 bullet points need to flash in your mind. Did the applicant meet their burden of proof? And the facts that we've got, do they support the conclusion that I'm making? And if you're not sure, then the answer is no, okay? The answer is no. We talked about conditions of approval. They need to be proportional and reasonable. They need to be measurable and trackable. Obviously, in writing, they need to comply with federal law, and they need to comply with your UDO stuff in section 2410. Okay? That is it. We'll save best practices for next time. Those are some of the pro tips that we use. Things like, hey, this is how you do seating, or this is how I handle the question when there's people arguing in front of me, that sort of stuff. We'll save that for next time and talk about the hypotheticals. The presentation that you've got lists some of the hypotheticals that I was thinking about. Have a look at those and share your thoughts with Conrad if you want me to talk about those, or there's some other aspect that you'd like to cover. And I'll come back and see you guys, at some point in the future when you don't have a heavy caseload, and we'll do some hypotheticals. Okay? And with that, I thank you. I really appreciate the opportunity to talk with you guys, and it's good to see you guys.
We appreciate it. Your time, Chad. Thanks for coming tonight. We appreciate it.
Thank you.
All right. Do we have any other business? Anything from staff?
Well, Chair Bizzle, just thank you for sitting in through this training. It's been wonderful to sit here and just listen. I'm learning new things also, so I think I'm hopefully that you're walking away from tonight feeling more confident, more knowledgeable about your role as a board member for the Board of Adjustment for both our existing and our new members. So thank you for taking the time this evening, and we'll coordinate with Chad to see if when we can continue the information here. No other notices. I'm just thinking out loud here. We do have a vice chair that will have to be voted on. I think we'll shoot for our March meeting. So maybe, Chad, we can bring you on that if we don't have that way we don't have to meet in February. There's no cases to date for February. So maybe in March when you have when we're going to elect the vice chair. And then I think the town clerk might, if you haven't signed any of the policy or anything, that the town clerk just be aware that Heidi might ask you to sign something. But no other updates. Thank you, sir.
All right. Anything from the board? Everybody ready to go home? All right. Well, welcome, Karen.
Thank you.
And with that, I'll entertain a motion to adjourn.
I move to adjourn.
Second.
Have a motion and a second. All those in favor, stand up and go home. How about that?
Aye.